Okay, let's unpack this. Imagine the scenario. You're in a tough legal fight, maybe an accident, something complex. It's just dragging out, right?
Right. Settlements can take ages, trials even longer.
Exactly. And meanwhile, you need cash. Like now, for rent, bills, maybe medical costs. Just waiting puts this huge squeeze on you.
And that's really where this idea of consumer litigation funding often comes up. People sometimes call it lawsuit lending, other names too.
It's basically a way people try to get in advance, based on what they might get from their case, but before it's actually finished.
hmm And while it can be a lifeline for some people, the industry itself hasn't always had the same level of regulation as, say, traditional loans. That's led to concerns.
Concerns about what exactly? Like hidden fees.
Yeah, things like transparency, how the costs add up, whether consumers really grasp the full picture, the total cost, and all the terms. It can get complicated.
Which is precisely why New York State decided to step in, create some clearer rules. So today, we're doing a deep dive into that specific law, Senate Bill 1104A. It's called the Consumer Litigation Funding Act.
Yep. And our mission today is basically to walk you through parts of the actual bill. We'll pull out the key definitions, the requirements, what's allowed, what's not. The goal is to give you a clear understanding of how this works now in New York.
Get to the core info fast.
Exactly.
Perfect. So jumping right into the text of the bill then, how does it actually define consumer litigation funding? Because that definition, that really sets the whole foundation.
Right. The bill calls it a non-recourse transaction. That's the key phrase. It's where a company, the funder, basically buys a piece of the potential future proceeds from a consumer's legal claim.
Buys a piece.
Well, buys a right to receive an amount from those proceeds, and the consumer assigns that right. The proceeds could come from a settlement, a judgment, an award, whatever the outcome.
Okay, and non-recourse is critical here, you said?
Absolutely critical. The bill defines it clearly. Repayment comes only from the money the consumer gets from their legal claim. If the case doesn't result in any proceeds, well, the consumer generally doesn't owe the funding company back.
Okay, so the risk is mainly on the funding company, not on the consumer's house or other assets. The bill locks that in.
Precisely. It codifies that right in the main definition.
So who are the main players this bill is talking about?
Okay, so you have a consumer. That's defined as a real person, a natural person, who has a legal claim pending and lives in New York.
Lives or is domiciled, right?
Right. Then you have the consumer litigation funding company, or just company. That's the business, the entity that makes these funding contracts with consumers, specifically contracts under $500,000.
500,000, okay. And the bill is careful to say who this doesn't apply to, isn't it? Like who's not covered by these rules?
Yes, that's important context. It excludes a immediate family helping someone out. It also excludes banks that lend money to the funding companies themselves. They have their own regulations.
Okay.
And it doesn't cover the consumer's own lawyer or accountant providing their normal services. The focus is really on those third-party businesses whose main job is offering this specific type of funding directly to consumers.
Got it. So we have the transaction type non-recourse, the consumer, and the company. What about the money itself? How does the bill talk about the cash the consumer gets versus the costs?
Good question. The actual cash given to the consumer upfront is called the funded amount. And the bill stresses that this amount doesn't include any fees or charges.
Just the principal, basically.
Exactly. Then there's the term charges. This is defined really broadly to cover everything the consumer owes back on top of that funded amount. Fees, interest, service charges, admin costs, whatever name they give it, it falls under charges.
So it's meant to capture the total cost beyond just paying back what you borrowed.
That's the clear intent. Funded amount is the principal. Charges are all the extras.
Okay, so we know what it is, who's involved. Why did New York decide this needed regulating now? What's the bill's stated purpose?
Well, the legislative intent section right in the bill says it's to promote consumer protections in these deals. It recognizes that this type of funding has grown and it needs, a proper regulatory framework.
To make sure consumers aren't getting a raw deal, essentially.
Basically, yes, to ensure they're not being exploited.
And the bill doesn't just state that as a goal, it actually sets up requirements in a few key areas, right?
Oh, yeah, absolutely. It lays down rules for the contracts themselves, what has to be in them. It mandates registration, like licensing for the companies. It puts some really specific duties on the consumer's lawyer.
Interesting.
And it lists things funding companies just can't do, plus penalties if they break the rules.
So the underlying idea seems to be that without these clear rules, maybe consumers face contracts that were hard to understand, costs that spiraled, or even pressure related to their actual lawsuit. This bill looks like it's trying to build guardrails against that.
That definitely seems to be the aim. Moving from a less structured environment to one with required disclosures, state oversight, clear rules of the road.
Okay, let's get into those specifics. Starting with the contract. What does the bill demand to make sure someone actually gets what they're signing?
This is a big focus. The contract has to be written clearly, using common everyday words, not dense legalese designed to confuse.
Makes sense?
It also has to be totally filled in before the consumer signs. No blank space is left to be filled in later. And the consumer has to initial every single page.
Initialing every page, that seems like a small detail, but probably forces you to actually look at each page.
It encourages that, yeah.
Hmm.
The contract also needs a clear statement saying there are no hidden fees, that the only charges owed are the ones disclosed right there.
Okay.
And here's a really important one. If a consumer gets more than one advance from the same company for the same lawsuit, any later contract has to show the total cumulative amount owed across all contracts up to that point.
So you don't lose track if you take multiple advances. You see the running total right there on the latest agreement. That's smart.
It prevents that potential confusion, yes. And related to that, the contract has to state the maximum possible amount the consumer could ever owe under that specific contract.
A ceiling amount stated up front.
Yes, with very limited exceptions, like if the consumer commits fraud or seriously breaks the agreement.
Hmm.
But otherwise, you see the top-end potential cost. And it has to clearly explain how the charges build up over time.
So, clear language, fully completed, initial pages, all fees disclosed, cumulative totals shown, and a maximum cost stated. That's a lot more clarity baked in.
It is. Significant changes.
Does the consumer get any chance to back out if they have second thoughts right after signing?
Yes, absolutely. There's a mandated right to rescind, basically, a cooling off period. It's 10 business days.
Okay.
Within 10 business days of getting the funds, the consumer can cancel the whole thing, return the funded amount, and owe nothing further. No penalties. And this right has to be stated clearly in the contract in 12-point bold type.
That's pretty standard consumer protection, giving people a moment to reconsider. Now, you mentioned the attorney's role. This sounded like a really unique part of the New York law. What exactly does the bill require the lawyer to do?
Yeah, this is where the New York approach gets quite distinct. The funding contract itself must include a separate written acknowledgment signed by the consumer's attorney.
Signed by the attorney. What are they acknowledging?
Several things. First, the attorney attests that they've actually reviewed the mandatory disclosures required by the bill with the consumer.
So the lawyer has to confirm they didn't just hand the document over, but actually went through the key parts with their client.
Exactly. It's a check to make sure the consumer understands. The attorney also has to attest that they're working on the underlying case on a contingency fee basis.
Oh.
And critically, they attest that the proceeds from the case will be handled through their official attorney trust account or a settlement fund set up for the case, and that they, the attorney, are obligated to manage the disbursement of those funds, including paying the funding company according to the contract.
Wow, so the bill puts the responsibility squarely on the attorney to handle the repayment from the settlement funds.
It really does. And there's more. The attorney also has to attest they haven't received and won't receive any kind of referral fee or kickback from the funding company for this deal.
Preventing conflicts of interest.
Precisely. And they also attest that they have not given the consumer any tax advice, advice on public benefits, or general financial advice specifically about this funding transaction. Their role is legal counsel on the case, not financial advisor on the loan.
Keeps the lines clear. That makes sense. Prevent the lawyer from pushing funding for their own benefit or giving advice outside their expertise.
Right. And there's a huge consequence tied to one part of this acknowledgement. The bill states that if the specific attestation about handling the funds through the trust account or settlement fund isn't completed and signed by the attorney, the entire funding contract is null and void.
Whoa, just like that. If the lawyer doesn't sign off on that specific point, the contract is basically invalid.
That's what the text says. It shows how seriously the legislature views the attorney's role in making sure the money gets handled correctly when the case resolves. The bill does add a note that if the consumer switches lawyers, the contract isn't automatically void, but the new lawyer would need to fulfill these roles at settlement.
Okay. What about sharing case info? Does the lawyer talking to the funder risk attorney-client privilege?
The bill addresses that directly. It clarifies that communications about the funding between the lawyer and the company are considered within the scope of privilege. But, and this is key, The attorney can only share privileged details about the actual legal case itself if the consumer gives explicit written consent.
Another protection layer for the client's confidential case details. Okay, so we've got the contract rules, the attorney's critical role. What about the funding companies? What does the bill say they cannot do?
There's a pretty detailed list of prohibitions. First, they can't pay or accept referral fees or kickbacks involving attorneys, their staff, or medical providers connected to the case.
Standard stuff, anti-kickback.
Right. They also can't use false or misleading advertising.
Makes sense. Truth in advertising.
They're also barred from referring consumers to specific lawyers or doctors. They can point someone who needs a lawyer towards, like, a local bar association referral service, but they can't steer them to lawyer X or clinic Y.
That's important. Prevents the funder from potentially controlling who handles the consumer's legal or medical care.
Exactly. They also can't knowingly fund a consumer who's already promised proceeds from the same case to another company unless they make arrangements to pay off that prior company, or they agree to fund alongside the other company with everyone's consent.
Prevents stacking claims on the same potential money without coordination.
Right. Now, this next one is probably one of the most significant prohibitions in terms of consumer control. Funding companies are explicitly forbidden from having any say, any influence, any role at all in deciding how the legal claim is handled.
Meaning what exactly?
Meaning decisions about strategy, whether to settle, when to settle, for how much, all of that remains solely with the consumer and their attorney. The company can ask for basic status updates like, is the case still active? But they cannot interfere with the lawyer's independent judgment or try to pressure the consumer on settlement decisions.
That is huge. It draws a very bright line. The funder provides money, period. They don't get involved in running the lawsuit.
Absolutely. A very clear separation. They also can't try to get the consumer to waive legal rights, like the right to a jury trial.
Okay.
And they can't knowingly use the funding money itself to pay for things like court filing fees or the attorney's fees.
But the advance is meant for the consumer's living expenses, things like that, not for financing the litigation costs themselves.
That seems to be the intention. The bill also adds a related rule for attorneys. The consumer's lawyer, or any lawyer who referred them, can't have a financial stake in the company that's providing the funding to their client. Another conflict of interest prevention measure.
Okay, this is all adding up to a pretty regulated environment. Let's talk about repayment and cost. This is often the trickiest part for consumers. How does the bill structure the repayment? And crucially, is there a cap on how much it can ultimately cost?
Right, this is key. The bill approaches this in sort of two related ways. There's one section, 899-day IFF, that says the total amount to be repaid, the funded amount plus all the charges, shall be a predetermined amount based upon intervals of time from the funding date through the resolution date.
Okay, so based on time intervals. Like the cost goes up every 6 months the case is open or something like that.
That's how that section frames the structure of how charges accumulate in the contract.
Okay.
It also specifically says the repayment amount shall not be determined as a percentage of the recovery.
So the contract itself can't just say, you owe us 50% of whatever you get. It has to be based on how long it takes.
That's what Section 899F dictates for the calculation method within the contract. However, there's another really critical part later in the bill, Sections 899E and 899dig, that puts an overall cap on the total charges that can be collected, and this cap is tied to the recovery.
Ah, okay. A cap. How does that work?
This part says that if the consumer's attorney, or the consumer if they end up without one, gives the funding company a written statement confirming the final gross proceeds of the case.
The total amount recovered before deductions?
Yes, the gross amount. Then the maximum amount of charges the company can collect shall not exceed 25% of the gross proceeds from the applicable legal claim.
Okay, let me see if I get this. The contract calculates the potential amount owed based on how much time passes. But no matter how high that time-based calculation gets, if the case settles and the lawyer confirms the total recovery, the actual charges the company can take out are limited to 25% of that total recovery amount.
You've got it. That's the interplay. The time-tier structure sets the potential amount. But the 25% of gross proceeds rule acts as a hard ceiling on the charges. So if the time calculation leads to charges that are, say, 30% of the gross recovery, the company can only collect charges equal to 25% of the gross recovery, plus the original funded amount back.
That seems like a really significant protection. It stops the cost from just growing endlessly if a case drags on for years, and it anchors the final charge to the actual success of the case.
It provides a definite statutory limit relative to the outcome. And the bill also explicitly bans prepayment penalties. You can't be charged extra if your case settles quickly and you pay back the funding sooner than expected.
Good. No penalty for a fast resolution. Okay, so beyond the contract terms, what does a company actually have to do to operate legally in New York now?
They have to register with the New York Secretary of State. It's not an unregulated field anymore. They need formal state registration to do this business.
Registration. Okay, so what does that involve? Filing paperwork? Fees?
Yep. They file an application, pay fees, $500 to start, then $200 every 2 years to renew. And they could actually look into the company's character and fitness, assess if they seem likely to operate honestly and fairly.
So some level of vetting by the state.
Yes. And the Secretary of State also has the power to require the company to post a bond or get an irrevocable letter of credit, potentially up to $50,000.
As a kind of security.
Right, to help ensure they can meet their financial obligations.
Did companies already doing business get time to adjust?
Yes, there was a grace period.
Hmm.
Companies that applied within 180 days of the law taking effect could keep operating while their applications were reviewed. But it's really important. Funding agreements made before this law took effect are grandfathered in, and they aren't subject to these new rules.
Got it. So these regulations only apply to contracts signed after the law became effective. Does the state see the actual contracts they're using?
Yes. Companies have to file their standard contract forms with the Secretary of State. They can't use a contract form in New York if it hasn't been filed.
So the state knows who's operating and what kind of terms they're generally offering. Is there any ongoing reporting required?
Yes, annual reports are due by January 31st each year. This is meant to gather data about the industry's activity within the state.
What kind of data do they have to report?
Things like the total number of funding deals they did in New York that year, the total dollar amount funded across all those deals, and this is interesting, the actual annual percentage rate charged for each consumer whose case was resolved and repaid during that year.
Wow, reporting the actual APR for completed transactions gives real insight into the effective cost.
It does. It provides transparency on what consumers actually ended up paying. And the Secretary of State is required to make this aggregate data public within 90 days. Things like the total number of deals and total funding, while keeping individual company and consumer names confidential.
Public data on the industry's footprint and cost, but protecting privacy. Seems reasonable. Okay, so with all these rules, what happens if a company just ignores them, especially if they knowingly break the rules?
The penalties are pretty stiff for a willful violation relating to a specific funding agreement.
Willful meaning they knew better, essentially.
Correct. If a company willfully violates the act in a specific case, the consequences are twofold. First, they completely forfeit their right to get any money back in that transaction. They lose the funded amount and all the charges.
They lose their entire investment in that specific deal. That's a huge penalty.
It's a very strong incentive to comply. Second, on top of losing the money from that contract, the company can also face a civil penalty of up to $5,000 for each violation, payable to the state, recoverable by the Attorney General.
Okay. Serious consequences.
Yes. The bill also includes standard language about severability. If one part gets struck down by a court, the rest of the law remains in effect.
And when did this all start?
It took effect 180 days after it was signed into law, giving everyone some time to prepare. So it's been in the law for a bit now.
Right. The bill also briefly mentioned assigning the right to the money and how the funding company's claim stacks up against other claims, like the lawyer's fees, right?
It did. It confirms the right to proceeds can be assigned. That's the whole basis of the transaction. And it clarifies that typically the attorneys lien for their fees, and any statutory liens, like from Medicare or Medicaid, get paid out before the funding company gets its share from the settlement money.
So lawyer gets paid, government liens get paid, then the funding company. Priority order.
Generally, yes.
Okay. We have covered a ton of ground here, really digging into the details of this New York law. Let's try to bring it all together for you, the listener. What's the big takeaway? Why should these specific rules matter if you're maybe thinking about this kind of funding or just trying to understand it?
Well, the big picture is that New York has really stepped up regulation in this area. It used to be much less defined. This law isn't just adding minor tweaks. It fundamentally changes the game by putting concrete consumer protections and transparency requirements right into the statute.
And knowing these specifics is actually quite powerful, isn't it? Like, knowing about the required disclosures means you know what information you should be getting upfront about costs and terms.
Exactly. And understanding the attorney's specific role that they have to review things with you, sign off, handle the payoff that clarifies their crucial position as a check in the system.
And knowing what companies can't do, like meddle in your case or steer you to certain doctors or hit you with hidden fees, knowing those prohibitions gives you power.
Absolutely. And being aware of how repayment is structured, and especially that 25% cap on charges linked to the gross recovery, that gives you a much clearer picture of the potential cost and its legal limits, even if your case takes a long time.
Plus, the registration and reporting requirements mean there's now state oversight and growing public beta about the industry in New York. It's moving out of the shadows, you could say.
It's really about equipping consumers in New York with clear rights, solid information to make informed choices, and setting up a regulated playing field for the companies involved.
So, this deep dive really shows New York trying to strike a balance, allowing access to funds, but with significant guardrails to protect consumers.
That definitely seems to be the intent woven throughout the bill.
Okay, so here's something to think about based on everything we've just discussed. Considering these very specific New York rules, particularly that unusual structure where charges build up based on time but get capped at 25% of the gross recovery, and the heavy reliance on the attorney to validate the contract and manage the payoff, how might these unique provisions fundamentally change the way funding companies actually structure their deals and operate in New York, maybe compared to other states with different rules? And ultimately, what could the long term effect of these specific rules be on the cost and even the availability of this type of funding for consumers who need it in New York? Something to chew on.